province and duty of the judiciary to say what the law is and not what it should be. And now I'm going to turn it over to John, who's going to introduce our speakers.
Thanks everyone for coming. It's my pleasure to be able to introduce both Professor Feldman and my former boss at Notre Dame Law School, Professor Garnett. Professor Garnett is a professor of law and concurrent professor of political science at the University of Notre Dame. Prior to joining the faculty, Professor Garnett was a visiting professor at the University of Chicago Law School and an associate with the Washington, D.C. firm of Miller, Cassidy, LaRocca, and Newen. He has written dozens of law review articles and book chapters on the freedoms of speech, association, and religion, and is currently working on a manuscript titled Two There Are, Understanding the Separation of Church and State. Professor Garnett attended Duke University and Yale Law School, after which he clerked for 8th Circuit Chief Judge Arnold and Chief Justice Rehnquist. And I think you all know Professor Feldman. He's asked me to save time and just sort of get right into the debate. So enjoy.
Thanks, Johnny. I appreciate that. Let me turn this mic thing on they gave me. All right, well, thanks again. It's really an honor to be here. I suppose that goes without saying, but you all are so fortunate and so, at Notre Dame, we might say blessed to be a part of this institution. And I hope you appreciate that. I hope you appreciate all that you've been given and that you make a lot out of it. It's a real treat to be here with my old friend and colleague, Professor Feldman. We met back in '98, which is 15 years ago, when he and my wife were clerking together in D.C., and he was nice enough to sneak me into the court for the law clerk basketball games. Even then, he had a good head of hair and I didn't. So the plan for today, as I understand it, is really for a conversation, not only between Noah and myself, but among all of us. And so I'm going to try to do that instead of give you a long lecture. I'm going to share a few general observations and offer a few suggestions, and then I'll try to leave plenty of time for Professor Feldman's response and for your questions. Because I gather that many of you are kind of in different places in terms of how much con law background you've had or the extent to which you've studied the First Amendment, I'm going to try to set the stage, provide some background, maybe sail at a kind of a pretty high level of generality. I hope that'll be useful rather than boring. First, a quick note about the title of this event. Regulation versus religious freedom. I want to clarify something about that I think is important. The point I think that I'd want to make and that Professor Feldman and I would want to discuss is not, I don't think, that regulation is always or necessarily somehow against religious freedom, or that religious commitments will always be at odds with regulation or activist government. I mean, that's not my view in any event. I think there's a whole lot of religious foundation for the idea that it's appropriate for the government to do a fair bit in its efforts to try to bring about the common good and promote human flourishing and all that good stuff. The point instead is that it does make sense, not just today in light of current events, but I think it always makes sense to think about the ways that regulation, including wise and enlightened and well-meaning regulation, can come into conflict with, but also sometimes facilitate, religious freedom. And also to think about how we can and should react to these conflicts when they arise. Now, in American constitutional laws, as some of you know, so again, I apologize if this is review, these church-state cases or these religious freedom cases, they usually come in 4 flavors or shapes. The first flavor, if you want, has to do with cases involving aid to or material support for religious activities. The paradigm cases here, as you probably know, are all the various aid to parochial school cases or school voucher cases, or more recently there's been some interesting litigation about the extent to which after a disaster like Katrina can government help rebuild a church facility and so on. Those are interesting cases. That's not really our subject today. The second category, which is very timely, has to do with public symbols, right? Religion in the public square. You can think here about cases involving holiday displays or a memorial cross out in the Mojave Desert, or perhaps legislative prayer in the town of Greece, 10 Commandments monuments in front of the Texas Capitol, cases like these, right? Again, that's a lot of the court's church-state work. I don't think that's really our focus. I don't think of those as accommodations cases. So this third category then involve requests for exemptions or other accommodations from laws that have the effect of burdening religious exercise or belief. We're not talking about laws that are singling out religion for special condemnation or discrimination. Those are unconstitutional, kind of everybody knows it, right? We're talking about cases that involve requests for exemptions from what otherwise are non-controversial and unobjectionable laws. Here you might think of sort of the most famous case probably in recent times has to do with a case involving peyote, right? The use of the drug peyote by members of the Native American church as part of their religious ritual. Peyote is illegal. They say that's fine. We get it that peyote is illegal, but there ought to be an exemption for its use in a religious context. Another relatively famous case from back when I think Noah and I were law clerks is from the City of Bernie case, had to do with historic preservation laws, right? Historic and pretty buildings are pervasively regulated, as is what you can do with them. But what if that building is a church? Should a church have some leeway, some exemption? The fourth category, which some people think is part of the third, and I want to suggest to you that it's not, is a weird one. It's not a very big one, but it involves cases that go to the limits on the government's jurisdiction over essentially religious questions. These tend to be kind of esoteric. They involve things like litigation over who's really the Archbishop of the Serbian Orthodox Church, right? Or who really owns the Cathedral St. Nicholas in New York? Or what really are the true teachings of the Presbyterian Church, right? Cases like that sometimes look like exemption cases. I think they're different. I think they're about true kind of church-state separation cases, but we can talk more about that if you want. Our focus is primarily on this third category, right? Now, the big question that I want to start off with, so I want to abstract from any particular accommodation dispute about peyote or historic preservation or anything else, and sort of put out what I think is a really big, hard question that Professor Feldman and I are wrestling with. And that is, why would we ever, quote unquote, accommodate anyone by, quote unquote, exempting them from a duly enacted valid law or regulation? Right? I mean, think about it. Presumably, we thought about this thing, right? In whatever the relevant legislative body or forum was, we debated it, we argued about it, we had hearings, we investigated, we weighed the pros and cons, we had elections, we voted, and then we picked a policy. And then someone comes along and says, I get it, you did all that, you jumped through all the hoops, you dotted all the I's, I don't want to follow that law. Right? Why would we ever say, like, oh, okay, then you don't have to, right? Why would we do that? And we usually don't, right? Usually we have something we do with people who say that, and we put them in jail, right, or fine them. But when it comes to objections that are raised or requests that are brought by people who invoke a religious reason, a religious obligation, our laws have traditionally often reacted differently, right? But why, right? Why would we do that? Why would it matter to us that the person's reason for not wanting to comply with an otherwise valid and duly enacted law were religious, right? Now, we do, just as a matter of fact and practice, we do accommodate religious believers in this way sometimes, and in my view, we should sometimes. But still, I think it's really important to start with that big question, right? I know it's framed kind of provocatively because we have to have that question in view and appreciate how serious it is before we get into the tricky business of figuring out why the answer is sometimes and when those sometimes are. So with that on the table, let me also highlight what I think are three pretty big and I think sort of brute facts that are important to this topic. These are facts that make the business of accommodation particularly tricky, I think. The first fact is that America is more religious than many other countries that have active governments and social welfare states. I think that's true. It's changing, but it's true. The second thing that I take to be a fact is that America is more religiously diverse than many other countries are, and especially we're more religiously diverse than are other countries that are religious, if you know what I mean. And then the third fact is that American governments do more today than they used to. And I'm not saying that sort of for good or bad, I just think it's something we can observe, right? But if you take those three facts and you add them together, our topic starts to look a little different, right? The topic then becomes something like religious freedom under conditions of active government, religious commitment, and religious diversity, right? What do we do then? So framing the topic in this way, let me propose an initial observation. Again, it's going to be obvious to some of you, but I think it's worth making explicit. It seems to me that a more active government, a government that does more, poses greater challenges. And this is true whether or not we like what the government's doing. But it poses greater challenges to religious liberty than does a smaller one that does less. Right? That's not because big government is inherently antithetical to religion. It's that there are more occasions for conflict between government and believers when government is doing more and when there are more believers. Right? So the inevitable challenges to religious liberty are increased by the fact that our political community is both, well, I shouldn't say both, is at the same time religiously diverse, religious, and that we have a reasonably active, not as active as some, but a reasonably active social welfare state. Right? This means that there are more flashpoints, more occasions for conflict. Right? If a government doesn't do anything, it's not going to come into conflict with people's religiously motivated action. If everybody believes the same thing, so if you don't have religious diversity, you're probably going to have fewer conflicts because the majority takes care of itself. Right? And of course, if you don't have very many religious people or no religious people, then also the occasions for conflict are reversed. Right? Now, it seems to me in a society that is both religious and religiously diverse, it's going to be difficult for government to avoid entirely these kinds of conflicts. Even a well-meaning, conscientious, rights-protecting government is going to not be able to avoid all of these conflicts, right? Even if it wants to. Well, so what, right? I mean, that is maybe our answer to the question, what should we do about this, is nothing, or at least nothing special, right? We should just keep doing what we're doing, namely, deliberating about laws, hopefully deliberating in a more edifying fashion than we've been doing in recent days. Let the marketplace kind of do its business and enact policies that we think, or a majority of us think, maybe a supermajority of us think, serve the common good. I mean, in politics, there are always winners and losers, and so we might think the fact that in a particular case, a particular loser happens to be religious ought not to change things, right? People often have reasons for wishing the law was different than what it was, and our answer to them usually is, we'll go out and convince people to pass new ones. But that's not, generally speaking, what we do. Right? But again, I think we should really, I want to take as seriously as I can the kind of force of that so what objection. So 25 years ago, in a really important and I think excellent law review article, one of your professors, Mark Tushnet, this is in 1988, I guess, wrote an article called The Emerging Principle of Accommodation of Religion. And then he had in parentheses, dubitante, which I think is fancy for I'm not so sure about it. Right? And he did a great job of kind of working through the state of the debate about whether and why we should accommodate religious freedom. And he said two things in conclusion, at least. One is, this accommodation business is theoretically more problematic than a lot of its supporters think it is. And it's also normatively more attractive than some of its opponents think it is. And so, isn't that an interesting state of affairs? Well, it is. So, I reread that article before coming out here. I mean, I think it's kind of good to reread it often. And I thought I'd really try to wrestle maybe again with the question he raises, which is, why would we do anything different with religious objectors, right? Assuming that our political process has been working fairly? Now, one answer would be to make some kind of ideal theory, first principles demonstration that would show, to everybody's satisfaction, meeting all the Rawlsian rules and all that good stuff, that religious reasons or religious motivations are just categorically different in ways that justify or trigger special government treatment. A lot of smart people have tried to make such a case. I actually think it probably can be made, but a lot of people think it can't. Recent books by Brian Leiter and some others you might have heard of making pretty strong pushback on the idea that you can show religion is special. I'm going to cheat and punt on that topic. Right? I'm going to say instead, just let's look around at our Constitution, our public law, our traditions, and we can observe that for better or worse, we have in our laws and in our practices treated religious motivations and religious objections differently. To observe that is not to say it's not worth arguing about whether we should, but we do have a First Amendment that uses the term religion and that seems to give it some distinctive treatment, right, in interesting ways. And more recently, we have positive law, right? We have the Religious Freedom Restoration Act, we have state-level type RFRAs, all of which invite and seem to require us to get into this messy business of accommodating religion, right? So I think we can then move on to saying, well, okay, how should we go about doing this? Now, with respect to the free exercise clause, and again, with apologies to those of you who already know this, the Supreme Court's view has become, I think, pretty clear on this. Although for a time, let's say 30 years or so, the Supreme Court said, even if it didn't actually do, but it said, the Constitution, the free exercise clause, sometimes requires governments to exempt religiously motivated behavior from otherwise valid laws. Now, they would say that, but the claimants almost always seem to lose. Then the Supreme Court, in a case called Employment Division versus Smith in the early 90s, abandoned that approach, or largely abandoned it. And the rule then became, and is now, that if you have a generally applicable neutral law, so it's not discriminating, targeting against religion, that happens to burden even sincere religious exercise, that's not a constitutional problem. Now, Justice Scalia, in a part of that opinion that's not always read as often, did say, look, our holding here is that the free exercise clause doesn't require these exemptions. Our holding is not that legislatures shouldn't get in the business of accommodating to the extent they can. And, as many of you know, the Congress pretty quickly in this kind of orgy of bipartisanship did, right? The Religious Freedom Restoration Act was enacted like a gabillion to not very many, right? And that law, there's a lot of complications we could get into, but I think it's safe to say, that law requires the government, the federal government, to take seriously religious objections and to give serious consideration to religious accommodation. So where are we now then in terms of the landscape? The Constitution rarely requires exemptions, but it does broadly permit them, not unlimitedly, but broadly permit them. And the question whether an exemption is going to be given or not in any case is largely now a matter of politics or of statutory interpretation. Right? Now, most religious freedom scholars think that's bad. I think it's probably fair to say most. Most people who study this stuff think Smith got it wrong. You know, big names, Michael McConnell, Doug Laycock, and others. I'm not so sure. You know, I don't know the history of the founding as well as some do, as well as Professor Feldman does. But I actually think it's not obvious that, as a historical matter, if we care about that, that early in our history, people thought the First Amendment required religious accommodations. People often extended religious accommodations, but they debated about it in politics and gave them or didn't, depending on whether they wanted to or not. Right? I'm inclined to think, actually, that given the kind of granular nature of the inquiry, right, given the very context-sensitive nature of the question whether or not we should accommodate religion, that it actually makes a lot of sense to have it be more of a statutory, legislative, common law type process than something that gets resolved in litigation about the free exercise clause. Again, I could be wrong about that. Certainly, that approach is risky. It's risky for religious freedom because you might say, anybody who's studied constitutional law and the Bill of Rights knows this, that one of the reasons why we have these entrenched constitutional protections is precisely because we don't trust politics to protect values in hard cases. And that's true. We have traditionally worried about that. So we still can, and there still is a role for the Constitution in this, and a role for federal courts. We can protect religious freedom by enforcing, for example, the non-discrimination rule, by making sure there's no religious coercion, and so on. But by and large, the business of accommodating religion and giving kind of exemptions to those who need them and who ask for them and who have strong cases for them, that's going to be done by us in politics, in statutes. Right? So maybe that's kind of one big takeaway, if there's any, in my remarks, is that as a historical matter, but also I think this is a pretty good thing, the debate about accommodation has sort of relocated from constitutional adjudication and the meaning of the free exercise clause to a more kind of case-by-case or statutory type approach. Right? Now, I said a couple minutes ago that religious objections can and should be accommodated sometimes. And I said that, in fact, in our history and tradition, they have been sometimes. Obviously, if anybody's related to Mr. Reynolds of Reynolds versus United States, you know that there's not always been accommodations, right? And our approach has kind of waxed and waned, and sometimes we've given in to political pressures, and other times we've stood up to them. But still, our approach has generally been for the last several decades, and is right now, I think, to accommodate religion to the extent that we can. Right? it seems to me we can say a few things about how we've gone about doing this. So we've tended to take into account both the nature and weight of the religious objection, right, and the nature and weight of the government's interest, the interest being served by the law that the person is seeking an exemption from. Right? We've taken into account whether or not the burden question is being imposed by the government or whether it's really being imposed by another private actor, and the objector is really seeking the government's help in response to that private actor. We've asked, as I think we have to, about the feasibility of an accommodation, right? And the cost and the efficiency, right? Can the requested accommodation reasonably, feasibly, efficiently be granted, or would it just be too hard? In some cases, we've interestingly asked whether the government has given other exemptions, other non-religious exemptions to the law in question. And if it has, then we basically put the burden on the government to show why it's not at least giving similar consideration to religious objectors. And of course, especially in Establishment Clause cases, we've looked to make sure that the requested accommodation wouldn't impose burdens on third parties. I mean, it's one thing for someone to come in and say, this neutral law is burdening my religious exercise. We can say, we get it, there's some pain on your side of the ledger, but are we going to move that pain to someone else? That's harder to justify. Now again, not to sound too Pollyannish, but as I see it, this is pretty much the right way to go. I'm going to set out 4 points in respect to that kind of Pollyannish conclusion, and then conclude. A first thought, it seems to me it shouldn't matter when we're involved in the enterprise of accommodating religion that the objector's beliefs seem weird, idiosyncratic, old-fashioned, or otherwise objectionable. That's usually going to be the case when someone's seeking accommodation because, again, the majority can typically take care of itself. A second point, it shouldn't matter too much. It has to matter some, but it shouldn't matter too much that the accommodation would involve some inconvenience to the government and some cost to the government. I mean, rights are sometimes expensive, right? Now, there are limits, but the mere fact that it might involve some inconvenience, some bureaucratic adjustments, shouldn't be enough to defeat the case for an exemption. Third, I think it's true that burdens on third parties matter, and that our ability to accommodate some objectors is going to be constrained by, I think, our obligation to not just move the burden from one person to another. Okay? And then fourth, it doesn't seem to me that it is necessarily an unconstitutional establishment of religion for the government to take those opportunities that it can to help facilitate the free exercise of religion. For a long time in the Supreme Court's cases, there was this sort of image of, between a rock and a hard place, like the Establishment Clause is pushing against religion and the Free Exercise Clause is pushing for, and what are we to do, right? I take the Establishment Clause's constraints on government action, I think, pretty seriously, but I don't think it's the case that, it's usually not the case, that the Establishment Clause means that efforts by the government to sort of reach out and look for ways that it can lift burdens that it's imposing on religious freedom. That's just a way of promoting the common good, which after all includes an environment of religious freedom. I don't think that's an establishment of religion. So, finally, as I'm approaching my hooking hour here, that sounded bad, sorry. Regulations, even good ones, sometimes impose substantial burdens on sincere religious beliefs and practices. We cannot always avoid imposing these burdens. We cannot always accommodate those who have these objections. There's something kind of tragic about this, right? But my point is, kind of a modest point when you think about it after 25 minutes. Sometimes we can accommodate these objectors. And it seems to me that we have good reasons in our constitutional text and traditions and values for doing so when we can. We should do it not only because that's what the law requires, because also it seems to me it's the right thing to do. So with that, I'll turn it over to Professor Feldman.
It's a huge pleasure to have Professor Garnett here. Rick is not only a great guy and a great basketball player and a great scholar, but he's also, and I'm really serious about this, he's a model of how someone in the scholarly world can argue positions for which he stands very firmly and consistently over years and do it in an extremely humane and discursive manner that facilitates conversation instead of blocking it. And that's really a model that I've always respected, and Rick has sustained it throughout his career. I just want to say two quick general things before diving into the question that Rick has very powerfully posed. The first is that one interesting thing about the accommodations question is that there's no clear conservative position on it, especially if you ask the question at the constitutional level. So Justice Scalia, who is the great missing figure from Professor Garnett's presentation, wrote the opinion in the Smith case. And I, by complete random chance, bumped into him in the airport this morning and actively did not bother him except to say a quick hello. But you know, it put in my mind very front and center that he had really two strong arguments against constitutional accommodation. One, as Rick mentioned, is an originalist argument. He has it out with Justice O'Connor in a series of opinions, and he clearly wins. And his argument is that at the founding, and we're talking now really about the individual states, people cared a lot about religious liberty, but they also believed that religious liberty could be trumped by an interest in public order and morality, which is what they thought was necessary to pass any laws. Every law had to satisfy, because they were in some sense libertarian, any law had to be serving the interests of public order and morality to be a valid law. So that meant that any law that the duly enacted legislature passed, or duly elected legislature passed, could trump somebody's religious interests. That's his first argument. His second argument is a jurisprudential argument. Justice Scalia, as you know, thinks that the rule of law is a law of rules, which is a catchy way of describing the idea that law should not be case by case by case. There should be laws that we know in advance and that apply equally to everybody. And Justice Scalia did not like constitutionally mandated accommodations because he said under them, and now I'm quoting him, every man is a law to himself. What he means is, if we have a general law, and I can raise my hand and say, excuse me, my religion prohibits me from fulfilling the dictates of that law, and we say, okay, Constitution exempts you, then we won't know, on a given moment, which laws apply. There are lots of people, diverse religious backgrounds, as Rick says, and there will be all sorts of exemptions, and Justice Scalia thinks that's jurisprudentially a disaster. He does accept, of course, the possibility that the legislature in the political process could choose to enact accommodations, and that's really the topic about which we're going to talk. So that's my first sort of general point. This is Justice Scalia's view. Lots of other conservatives, including Justice Alito, strongly disagree. And when he was on the Third Circuit, Justice Alito went to some lengths to try to kill Smith. And I think he's in the process now of trying to do the same. And I believe, actually, that although Rick is right, that right now the debate we're having takes place in the legislative sphere, and therefore we should talk about the normative question of what's the right thing to do, rather than what does the Constitution require. I think it's going back to the constitutional sphere. I think Smith is going to be chipped away and chipped away and chipped away until it's gone. I think Justice Roberts' general approach, and I think this has emerged as a distinctive view on his part, it's quite different from Justice Alito's, and it's the opposite of the Scalia-Thomas form of conservatism, is to chip away at holdings that he doesn't like rather than overturning them. Overturning things makes headlines, and headlines make for criticism, and they drive people to the polls to vote against an activist court. You can get, if you're a good lawyer, and Justice Roberts, Chief Justice Roberts is actually a brilliant technical lawyer, you can get most of what you want done without overturning big cases. Chip, 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 chip. And I think that's what's happening already to Smith. And in fact, I think in recent years, and this is a topic for another day, the Supreme Court has already substantially undercut Smith, especially in the Hosanna-Tabor case, which is a case about precisely what we're talking about. It's about whether anti-discrimination laws apply to a called minister within a religious school. And the court, in essence, said that there is a ministerial exemption, which is baked into the statute and which comes somehow from the Constitution. And if you ask, as I ask my First Amendment students, what's the difference between this and Smith, you could spend a lot of your class trying to answer that question, but there isn't really that much of a difference between that and Smith. This was a neutral and generally applicable law, and the court imported an exemption to it. So just as an example of where I happen to think we're going. So, you know, in 2-3 years, we can debate the constitutional question all over again, which will be fun. But now let's focus on this really interesting and in some ways more philosophically important question that Professor Garnett has put in front of us. And really, I would just formulate it this way. It's the normative moral question. It's not really a legal question. It's a moral question of when and under what conditions we should choose to accommodate religious belief when that religious belief motivates a request for an exemption from a neutral and generally applicable law. So we're just in the realm of the normative here. What's the right thing to do? And I want to say that there are really three issues that all cut against giving exemptions, all of which really need to be thought through and dealt with. Now, I'm not saying we shouldn't grant exemptions. Of course we ought to, and under many circumstances. But Rick correctly put on the table the question of, how should we do the balancing? So I want to just introduce three features of the balancing, all of which I think should be of interest to conservatives. The first question is, whose word counts as to what the religious belief in question really is? One option is just to say that any human being who raises his or her hand and says, my religion prohibits me from doing X, automatically is granted the right to do so and is respected for saying that. That's not crazy. And in fact, Justice Scalia, in the Smith opinion, was very nervous about a court inquiring into whether religious belief is sincerely held. I want to suggest the problem doesn't only arise when we're worried about sincerity. It also arises under conditions where there's just diversity of opinion within the religious group itself. Right? And this is an issue which I think requires being taken really quite seriously, because we know that some religious institutions can speak with a single voice, and other religious institutions can't or don't want to actually value the idea of the individual conscience as the entity that can speak on behalf of the community. So when you're doing this legislative act of sitting around and having testimony in front of you and fact gathering and trying to figure out what you're supposed to accommodate, the question of who you listen to and how you weigh their opinion about their religion will become a central political question. And that should make us really uncomfortable, because it can often amount to a legislative body sitting in judgment as to, will the real brand of Lutheranism please stand up? Exactly the issue that in category 4 that Rick mentioned, the courts say we don't want to have anything to do with. There's a property dispute between two groups. Each says, I own this church. I'm the true Episcopal Church. The court says, whoa, I really don't want to touch this. It's a separate philosophical question of whether it's actually logically possible to avoid it, because someone's got to win. But we know that the court desperately wants to pretend that it's not involved. So that's a first question, the whose word counts. A second question has to do with incentives. And it assumes that religious people are exactly like all other human beings in this regard. And I will just ask you to assume that, although if you want to raise your hands and disagree, that's OK too. But I'll give you some concrete examples to support my view that humans are humans. If you create a system in which you get an exemption just by raising your hand and saying, I need an exemption, you're creating a significant incentive for people to find exemptions within their religious traditions. And if your religious tradition is sufficiently flexible that it can evolve and develop, and I would claim that all religious traditions are, although some pretend they aren't, then you're now having a developmental incentive to develop practices that will exempt you from general laws. And I'm assuming complete sincerity on the part of the entity speaking. So I'll give you the example of a case which I didn't take, but I was asked to take under the Religious Land Use and Institutionalized Persons Act, which is kind of like RFRA, but for the states. Lots of detail which I won't go into. And it was a case that came out of New Jersey, and it was a conservative synagogue that wanted to expand the size of its social hall, and in so doing, they wanted to expand to the very borders of their property, and their neighbors, who happened to be Orthodox Jews, didn't like this very much because they were about to lose any space around their yards. You could hardly blame them. And they would have felt the same way had it been a church, and the same way had it been an Orthodox synagogue, by the way. I get calls like this that are within denominations all the time. It turns out property ownership is more important than religion in certain matters. So I asked to see the papers, and they sent me the papers. And the papers included an affidavit from the rabbi of the synagogue saying that the social hall was necessary to accommodate bar mitzvahs, that the synagogue's membership numbers depended on having bar mitzvahs, that their old social hall was too small, they were going to lose members, and that the bar mitzvah was a crucial element of the Jewish life cycle and necessary to their religious practice, such that they would be substantially burdened under the terms of the law. It's a statutory requirement of burden, at least on one reading of our lupa, that they'd be substantially burdened, and they were substantially burdened by the fact that the zoning laws wouldn't let them expand the social hall. Now, from a classic Jewish legal perspective, this is just totally absurd. The bar mitzvah as a social phenomenon, as opposed to a day when you turn 13, was invented somewhere in the 17th or 18th centuries, and it consisted of a glass of whiskey and some dried, puffy bread. And it was only in America that it became a significant social phenomenon. And no authoritative text of any movement within Judaism would actually say that it's obligatory even to have a bar mitzvah. So in that sense, one was inclined to respond dismissively. But of course, as a sociological matter, they were quite right. I mean, I actually believed that the future of this synagogue probably did depend on improving the social hall. That wasn't crazy. So what are you supposed to do in a situation like that? And footnote, what you really don't want to do is to go into court and have to cross-examine the rabbi about his possibly perjurious affidavit about the importance of the bar mitzvah to his form of faith. Now, my point of bringing this up is that I think the rabbi acted in good faith. I think it's natural to expand one's religious commitments when they will benefit one. So there's no question that the Catholic Church opposes contraception. There are more complicated doctrinal questions about whether an institution affiliated with the Catholic Church that provides a general insurance product violates the conscience of Catholics or the Church itself if in this generalized insurance product it is compelled by law to provide contraception for non-Catholics. That's a question. I don't mean that there isn't an answer to it. There's a plausible set of answers. But imagine that you're within the church and you're deciding that question. If your answer is, no, it won't violate our conscience, then you lose your exemption. Or it's harder to make the political argument for your exemption. If you say, no, this is a core element of our faith, and you sincerely believe it, you're more likely to win in the fight. So there's a question of incentives. And I think this is also behind Justice Scalia's worries about exemptions as a general matter. And notice that it comes up in legislative exemptions, not just in judicial exemptions. The last is really the hardest, and I'll just describe it briefly because I can't solve it, but it will be an interesting thing to talk about. And that is this. When do you actually think, each of you, that sincere religious interests actually trump some legal or political commitment that you really care about? Not one that's minor and unimportant to you, but one you really, really care about. I mean, that is a really hard philosophical question, right? So, we can pose the question in different ways to bring out how rough it seems, right? What about discrimination on the basis of race? If that's a very important value to you, do you really think that a whole institution ought to be able to say, look, our religious beliefs compel us to discriminate. God told us some people are not equal to others, so you must exempt us from your laws. That's just an example of a really, really hard case. And what I'm saying is you have to ask yourself the philosophical question of, do you buy that? So pick whatever your favorite moral principle is, the one you care the most about, and ask yourself, now there's a person who believes, so your belief we'll call it X, and someone else believes that God told him not X. And he really believes it. And you have convinced the world, perhaps after hundreds of years of difficulty, that your view is morally correct, that racial equality, which is not an easily won principle, is a better and more important principle than racial inequality. I mean, it's been a multi-hundred-year battle to convince people of that. And now comes someone, maybe a lot of someones, who say, no, wrong. So at what point are you willing to say legislatively, hey, you're motivated by religion, so that's cool. And again, it's not a question of allowing that person to discriminate, let's say, merely in his or her own home or in his or her own beliefs, but in public institutional spaces. Maybe you believe, there are people who believe this, that religion always trumps. But even that view needs some examination. You could believe it if you believe that God's word always trumps, but then you have to believe that God is actually talking to all those other people, not just to you. And very few people believe that. Right? So then if you're defending, there are people who believe that. There's a kind of Baha'i kind of worldview, which is a very appealing view, that says that everybody who feels inspired by God is inspired by God. And it's a theological problem for people with those views, what to do with the people who actually hate in the name of God. Right? If you think that God is love and that God is talking to everybody, it's like a philosophical problem. Right? You have to maybe say, well, God's not really talking to those people, so now you're just like everybody else again. So it's a problem, right? So if you really believe, I'm going to shut up here, if you really believe actually that your religious belief is correct, you might be supporting exemptions for other religions in the name of consistency, which is what Rick suggested, in the hopes that when it's your ox that's going to be gored, you'll be able to, solve it. And that's a really nice thing, but notice that now you're already in a game of costs and benefits. You're already not supporting religious liberty because you believe in it. You're supporting religious liberty because you want it to protect you. And then once you're doing costs and benefits, you have to ask, are the little piddling accommodations that I'm going to want going to be worth suppressing some other principle that I really care about, that maybe my religion teaches me? Maybe my religion teaches me that all humans are equal. So maybe I'm willing to give up on my sacramental wine to get racial equality, because maybe I think that's what God wants me to do. That's not a crazy worldview. In fact, it's a kind of appealing worldview. So I want to just close there by saying that at its core, the philosophical problem amounts to, when your most important held religious belief is at stake, do you think that someone else should be able to trump that belief just because he or she says that God supports it? So maybe, Rick, you want to respond, and then we'll open it up? That'd be good.
I'll be really quick, and I feel like, I'm a big admirer of the Federal Society. I feel like we kind of dropped the ball this time, though, because you might have heard there's not a whole lot of disagreement here. I think Professor Feldman and I might...
Usually I end up yelling at whoever's invited, so it's okay.
I think we probably...
For those of you who are in previous years, you'll remember.
I think we probably would disagree in terms of a few cases of these general principles being applied, but I want to underscore, just in case I accidentally created any doubt, that I agree entirely that those three factors that Professor Feldman mentioned are relevant to and make more difficult not only the moral question about whether we should accommodate, but remember, it is also a legal question because we have these federal statutes that require us to go through this exercise. And I think all the factors that Professor Feldman mentioned are relevant. It is really tricky when you're trying to decide whether someone's faith is burdened to get into, well, what does your religion really teach? I know you said it's this, but what if, someone stands up and says, my religion teaches X, but the minister comes in and says, no, we don't. Then what do you do? That's difficult, right? What courts tend to do is to cheat a little bit. And they say, all we're going to ask about is sincerity. And as long as the person's sincere, then that'll get the claim going. But in the back of their mind, what the court is thinking is, if this belief seems kind of weird, we'll find a way to make them lose on other grounds. Professor Feldman's point about incentives is certainly true. And I think that's actually consonant with the point I was making about how when we're going about the business of accommodating, we have to be sensitive to and we have to worry about shifting costs onto third parties. And obviously, if the effect of an accommodation is just to give somebody a competitive advantage in the marketplace, that's probably going to be a reason that weighs against accommodation. Some requests for accommodation are like that. I think most aren't, right? I think the example that Professor Feldman mentioned about the Religious Land Use and Institutional Persons Act is a difficult one, right? Because sometimes in these land use cases, it really does look like the effect of the exemption is to get a real kind of financial edge. That's not always true, but it's something we should worry about. Third, big question, right? When should religious beliefs trump? My answer, which I hope I made pretty clear, is not always, right? We accommodate it sometimes. When we can, we should. Sometimes we won't be able to, right? The person comes in and says, religiously motivated human sacrifice for me. We say, not that you're insincere. We say you lose, right? So obviously, we do have political, moral, normative commitments as a community that are sometimes not going to give way. One of the factors we consider is the weight and strength of the government's interest. Is it compelling? Right? Is it sufficiently weighty to justify the burden on the objector? I think I can happily concede all that, but still want to keep in your view, and I think Professor Feldman would want to keep this in your view too, that there is a cost to the conscience of the objector when he or she is forced to yield even to the majority's shared view. Right? Sometimes we don't mind imposing that cost because we think the person's religiously motivated action is odious or really, really, really bad. Right? But that's not always going to be the case, and so again, we should accommodate to the extent we can, when we can, it seems to me. Circling back to Professor Feldman's first 2 points, I don't think that Justice Scalia was totally invisible from my presentation because I tried to say, I might have forgotten, that in the Smith case, he does say, after saying all the things that Professor Feldman pointed out about how exemptions is kind of creates this law unto yourself thing and it departs from the rule of law, it might, at least when judges are doing it, he does invite legislative accommodations, as you heard from both of us. I also want to say, just in the interest of loyalty to my old boss, that the position that Scalia took in Smith was Rehnquist before it was Scalia's.
True. That's true.
And then the final point, which maybe is a subject for another conversation between Professor Feldman and myself, I do think that the Hosanna Tabor case, which is really important and really interesting in 9-0, is one of these Category 4 cases and not a Category 3 case. I have no choice but to admit that I'm in the minority in thinking that, but I think it nonetheless. So I'll stop talking, and if you guys have questions, I know you have to leave for class, and if you do, I'm not offended, so run away. But if you have questions, I'm sure Professor Feldman and I can riff a little bit more. Yes?
Yeah, you mentioned that in certain cases we should make these religious accommodations. Could you give an example of one of the cases in which you feel that we should, and what makes that different from the situations in which we shouldn't?
Yeah, so, I mean, in my view, what the legislature did after the Smith case, which was to create a special carve-out from the drug laws for religiously motivated peyote use, was exactly what we should have done. And similarly, when the Supreme Court had a case involving a hallucinogenic tea that was used in a religious ritual a couple years ago, they said that was protected under the Religious Freedom Restoration Act. I mean, in those cases, there was no, you might worry about the incentives, like people, if they have a chance to use peyote, they're going to claim they have a religious motivation, but I think the sincerity inquiry takes care of it there. Allowing the religiously motivated use via statute didn't shift burdens onto any third parties. It might have created some inconvenience for the government because now there's peyote kind of moving around in the market. You can't have a one-size-fits-all, no peyote rule. You have to actually ask if it's being used. But it's not too damaging, no burdens on third parties. And the government's overall interest in regulating controlled substances and preventing substance abuse isn't being trampled on. And there's no kind of big foundational public commitment like racial equality that seems to me to be at stake in a case like that. So a case like that, it seems to me that it can work.
But it seems really unfair to Rastafarians, whose religious belief truly, and I'm not being flippant at all, whose religious belief is and practice has been for roughly 75 years, truly caught up in marijuana smoking, and who aren't going to win a fight like that, at least at the present, in the U.S. I mean, and that's another weird feature of granting accommodations. Yeah. And Justice Stevens always worried about this. If I give it to you and I don't give it to you, right, have I satisfied the basic principle of treating people equally on the basis of religion?
And the fact, and Professor Feldman's right, that the Rastafarians, at least at present, aren't going to win, that's not only due, it might not, I mean, to be fair, it's probably not due at all to some kind of like hidden legislative preference for peyote use over marijuana use by religious people, but there's a plausible argument to be made that just given the prevalence of use of marijuana as opposed to peyote, if you allow an exemption for marijuana, religiously inspired marijuana use, it's going to complicate the government's drug enforcement efforts more than would a peyote exemption. I actually think they should give it in the case of religiously motivated marijuana use as well. But you can see the argument that uses some of the factors that Professor Feldman and I were talking about that makes those cases look different. The fact that those two cases look different, in my view, kind of supports the approach, let's call it the Rehnquist approach instead of the Scalia approach, that you see in Smith. Right? It allows us to take into account more of these kind of context-sensitive factors. Yes, sir.
I just want to touch upon a point that Professor Feldman made. You implied this with your remark in regards to kind of a real Lutheran, sect stand up, and it kind of touches upon one of the insidious features about religion that for many rests upon the laurels of interpretation. And so, aside from the concept of jurisprudence and how justices have kind of interpreted certain cases over time, how do you feel as a society today we should define a particular religious value for a particular religion?
Well, I mean, I think we share the feeling that it's very worrisome for the state to do that at all. I mean, this is a serious, serious, serious problem because there will always be dissenting views within any religious tradition. And so it's very worrisome for the state to do this. I mean, one issue, we didn't talk about it today, but where Rick and I do have some difference is on the state's attitude towards whether it interacts with the individual religious believer or whether it interacts with the institution of the religion, right? The believer or the church. And without oversimplifying either of our views, I think we probably both agree that our Constitution as originally designed was more focused on the individual believer, which solves this problem while creating other problems. Right. And that's because the framers were Protestants, and they didn't care about Catholics, and if they knew about them, they didn't like them. And Protestantism emphasized the individual believer, because that was sort of the whole point of Protestantism. So, in that context, our constitutional system evolved in a way where it might be able to solve this problem by saying we're not going to have to worry about it. Anyone who says I'm X is an X. But the problem is that in the real world, where actually people belong to multiple denominations, some of which are institutional denominations, you sometimes do have to deal with an institution and then you have a serious problem on your hands.
Yeah, as a descriptive matter, what we've done is when it's an individual believer, we tend to defer heavily to that believer's report of his or her subjective beliefs. And we look at sincerity, but it's very deferential. What we've done in cases involving institutions is kind of a two-track thing, right? If it's a hierarchical religious tradition, and sort of we know them when we see them, we tend to defer to their internal authority structures. And when it's not, when it's congregational, then we sort of defer to the outputs of their democratic processes. If the mics weren't on and I wasn't such a genial guy, I'd say, I thought the point of Protestantism was so Henry could get the church's money, but that's not.
Not to Martin Luther, it wasn't.
Yeah, so this question is based off of Bob Jones University. So I'm wondering what's going to happen in 5 or 10 years when, say, a church, so to take a contemporary issue, a church says we're not going to do same-sex marriages. And then someone comes and says, well, you should lose your tax-exempt status because of that, because it's against public policy. And let's say that a majority, says that that's true. So Bob Jones was like a university. What happens when it's the actual church saying this is against our religious belief? Is there any combination made for that, or does it just lose its status?
Well, it's a great question, and I don't know. I mean, I guess I suspect that as a political matter, that obviously, although views on that matter are changing a lot and will continue to change, I think, in that direction, I think it'd be a pretty big step in our political community to sort of take away, for that reason, the tax exemption of some pretty big religious denominations. I think at lower levels.
I would say it further. I think that would be a free exercise violation. I mean, if you took the same-sex marriage example, if you passed a law that said every church that does not perform same-sex marriages loses its tax-exempt status, that looks more like a Lukumi Babalu IA kind of case. That's targeting a specific religious practice, unlike the Bob Jones situation, where it was a general preference for racial equality.
Yeah.
I mean, so I think it would be constitutionally protected under those circumstances. And what's more, I think that the worry about it that's out there in the world is, I think, the product of, I mean, it's a very complicated story, but I think it's the product of a political attempt to redesignate attention and to come up with a new argument about why same-sex marriage is in fact threatening to traditional religious dominations, and I think this is not a convincing version of that. The background, of course, is that this is because the system was stacked so that religious groups couldn't make their actual argument against same-sex marriage, which was that it's violative of religious principle. So the system, in my view, shouldn't have been stacked that way in the first place. But once it was stacked that way, religious groups needed to come up with secular arguments for why they oppose same-sex marriage. And this worry, which to me is not a realistic worry, that their religious practice in their churches will somehow be affected by the state policy, seems to me to be constitutionally unfounded.
I think there are some lower level disputes, sort of not like losing your tax-exempt status entirely, but that are sort of like a conditioning of benefits and access and stuff, where I don't think it's unreasonable to sort of expect that, again, in some municipalities and some jurisdictions, there'll be things like, if you want access to the combined federal campaign, or if you want to be able to use this facility, or if you hold yourself out as a public accommodation, there'll be fights along those lines, I think. But I don't want to be Pollyannish on this front either. I think that the basic idea of a broad tax exemption for all religious groups, kind of whether we like them or not, is pretty well baked into our tradition now. You want to talk after? I know it's one of you guys want to go, and we can talk. Is that all right, David?
Yeah.
All right. Thank you, guys.
Keep
Keep in touch.